Hello my lovely people, good morning, good afternoon, good evening, good night. Welcome to my YouTube channel. My name is Jen. If today is the first time that you are seeing me, thank you so much for stopping by. My return subscribers, I love you, thank you. So I don't know if you guys saw this, the judiciary, they finally woke up. Wow. This is not the first time we had it anyway. They said the judiciary, that that the judiciary had been let down, this and that rubbish nonsense. The people saw the fake certificate and did not do anything about it. The people that saw all manner of things during election time, and they saw somebody who forfeited 460,000, and I don't know why they are coming out now to speak. But in case you're interested to hear what they are saying, I beg you watch the video and send other people that are interested to watch their rubbish, because I don't think any Nigeria are listening to this. I don't think any Nigeria cares about them. I don't think any Nigeria, because the people that they are working for have already promised them. They have bought them cars. They are building them houses. They are, no matter what you hear this man say, no matter what you hear them say in this video that I'm about to put for you, don't believe them. They are a piece of rubbish. All the school that they say they went is just rubbish, because all they will do is to rig election. Because when you see the truth and don't say it during election time, they brought everything, all the news for you to judge it according to the way. The people that took a number 4 person and made the person governor in Imo State is these people. Whatever it is that they're saying, Nigerians are not buying it. Don't worry, as they are building you house, Nigeria, you go be alive to live in the house. No, you have to live now. Live long enough to be in the house that they are building for you, instead of making the country great so that everybody would, no matter where you are, you will have peace of mind. You guys decided that it will not happen. You will go for the highest bidder. Whoever gives you more money, that's where you will go. So hear the rubbish that they are saying here. When you finish, I beg, share it from me to you. Thank you so much for watching. Bye-bye.
As I stated in my address last year, the opening of Igbo year is a time for reflection, renewal, and dedication to the values of justice, fairness, and the rule of law. It provides an opportunity to acknowledge the work by the judiciary in the last year, while also looking forward to the challenges faced in the period under review, as well as opportunities that lie ahead. The opening of the legal year is consequently more than a ceremonial occasion. It is a moment when we, as officers of the law, pause to reaffirm our dedication to upholding justice, ensuring the rule of law, and protecting the rights and freedoms of all Nigerians. The judiciary is, after all, the bedrock of our democracy, and it is through the work we do here that justice finds expression in the everyday lives of our citizens. Upon assumption of office as Chief Justice of Nigeria, my Lord Honorable Justice your Lordship made it clear that the court's urgent task was restoring public confidence in the judiciary. Thus, your Lordship has consistently reminded judges of their sacred oath. Addressing newly appointed judges recently, your Lordship ordered them thus: let your judgments be reasoned, impartial, and courageous. The judiciary, as the final arbiter of justice, depends on the credibility of its officers. Each of you now bears a share of that institutional body and of that honor. We know the many structural reforms undertaken by the CJN upon assumption of office. I'll mention a few. The embrace of technology as a tool for transparency and efficiency. The merging of the rules of court. The merging of the court records processing unit into a single unit. Ensuring better case management and drastically reducing cases of missing files. And the creation of central information unit to give lawyers and litigants real-time access to case information. Highly commendable is the scrapping of the paper-based and cumbersome enrollment of new lawyers and replacing it with a digitized process. Thus, details of new wills are now uploaded online, with candidates completing enrollment digitally and receiving their enrollment numbers electronically. Posterity will always praise the new NJC transparency policy, which requires that all judicial appointment memoranda will now be published at the initial stage as part of the comprehensive reforms in the judicial appointment process. Despite these efforts, more work needs to be done about changing the negative perception of the judiciary, which is best captured in the words of His Eminence, the Sultan of Sokoto, Mohammed Saad Abubakar, in his speech at the opening ceremony of the Nigerian Bar Association Annual General Conference in Enugu, when he warned that today justice is increasingly becoming a purchasable commodity, and the poor are becoming victims of this kind of justice, while the rich commit all manner of crime and walk the street scot-free, he said. The Sultan's speech once more reminds us that perception is greater than reality, and that with reality there is not much room to maneuver. With perception, we can exaggerate or modify according to the need. The Sultan's statement that the rich evade accountability while the integrity of the judicial system is being undermined by corruption and inequality once more reminds us that perception is very important. And as we always say, now public confidence in the judiciary may have plummeted, but we can reverse many of the negative perceptions in this legal year. The computerization of litigation process, including electronic recording of court proceedings in all superior courts of record, is a measure that must be bettered with utmost urgency. Nigerians, particularly those from rural or marginalized communities, should be able to access the justice system at very little cost. The various rules of court must be amended to provide for e-filing, virtual hearing, and speedy dispensation of cases. My lords, it's now 26 years since we returned to democratic rule. In those times, our democracy has been tried in various ways. I recall the promptness with which this honorable court resolved the question whether the decision of Atiku Abubakar to run for vice president after winning the governorship election in Adamawa State entitled INEC to conduct fresh elections, or in the circumstance, allow for the swearing in of his running mate, Boni Haruna, as governor. This court was also ready to resolve the question whether a president could remove a sitting vice president merely because he had decamped from the president's political party. It interests us to note that the case, reported as AG Federation and Abubakar citation supplied, started in the Court of Appeal via the originating summons filed on January 4, 2007, on February 7, 2007. On February 7, the matter was heard and judgment delivered by the Court of Appeal. The Court of Appeal to the Supreme Court was determined on April 20, 2007. The judiciary was hailed for coming to the rescue. Indeed, Nigerians and the international community praised the judiciary as the bastion of the rule of law. It was widely celebrated as the last hope of the common man. Nigerians want to see this reflected in all issues confronting our democracy. This court successfully handled over 1,000 pre- and post-election cases within 60 days on the filing of the notice of appeal. In a speech by the President of the Federal Republic of Nigeria, President Bola Ahmed Tinubu GCFR, declaring the end of the state of emergency in Rivers State, the President said that there were no less than 40 cases instituted before the various courts, including this court, challenging the declaration of emergency. It is really troubling that only one of the cases was decided before the expiration of the state of emergency. The one initiated before this court does not have a hearing date, even after the expiration of the 6 months period. The last time a state of emergency was declared in Plateau State, it took this court more than 2 years to decide the matter. The judgment is reported as Plateau State and Attorney General Federation citation supplied. At the time of the judgment, the people of Plateau State had forgotten that a state of emergency was ever declared. This is in spite of the fact that by the court's record, the case was filed on 24 June 2004, about 36 days after the declaration of the state of emergency in the state, and justice judgment was only rendered on January 2006. What is more disturbing is that the Supreme Court missed the opportunity of spelling out when the President can declare a state of emergency and the extent to which the declaration will affect democratic governance in the affected states. Nigerians really wanted this honorable court to determine whether the President, in the exercise of the powers under Section 305 of the Constitution, can dismantle democratic structures in a state by suspending the governor, deputy governor, and members of the House of Assembly. If, for example, the court subsequently answered this question in the negative, of what benefit will it be to the people if the decision comes after the state of emergency has been lacked by a fraction of time? Delay in deciding such weighty constitutional matters risks sending the wrong signal that the judiciary is indifferent to issues that affect governance at its most fundamental levels. A prompt determination would have clarified the law, reinforce federalism, and ensure that the wheels of government and the grassroots continue to run without hindrance. My humbly note, my lords, that both the cases of Adegbenro and AG Federation and Williams and Majekodumi, number 2, citation supplied, which border on the exercise of powers under the State of Emergency Act of 1962, were decided during the period of the declaration of the state of emergency. As the saying goes, justice delayed is justice denied. Clause 40 of the Magna Carta of 1215 states this principle as follows: to no one will we sell, to no one will we deny or delay justice, or deny the right of justice. Where there is delay in legal process, it harms the victims and undermines the accountability, thereby effectively denying justice. The NBA urges this honorable court with greatest respect to make a mark in history, by ensuring that matters of urgent national importance are not left in limbo. Swift and decisive justice reinforces the court's role as a stabilizing anchor of our democracy. My equally use this opportunity to call on this honorable court to fix a special session for the hearing of appeals to the court against decisions of the Legal Practitioner Disciplinary Committee, as issues of discipline appears not to be receiving the priority attention it deserves, as well as clear the confusion as to whether appeals can lie directly from this court from the decisions of the LPDC. This call has become pertinent in the light of recent decisions by this court declining jurisdiction and referring parties to a non-existent appeals committee of the body of benchers. We thought this matter had been laid to rest by the decision of this honorable court in Obia Jolonwano to an NBA, decided in 2019, citation supplied, where this court held by Kuman Bayang Akas JSC retired that any direction given by the disciplinary committee against a legal practitioner invariably is challenged at the Supreme Court, and this is the rationale for excluding the Chief Justice of Nigeria and Justices of the Supreme Court from being members of the disciplinary committee. And the court went on in that case to acknowledge that Mohammed Adoki, as Attorney General of the Federation, had regazetted and incorporated the provisions of the Legal Practitioners Amendment Decree of 1994, which abolished the Appeals Committee of the Body of Benchers and gave direct right of appeal to the Supreme Court. My lords, a look at the recent shortlist of candidates for appointment to the Federal High Court bench shows that majority, and by estimation about 80% of the names are either staff of various judiciaries, most likely registrars, legal advisors, or officials from government agencies. There is a dearth of private legal practitioners in this list, as well as many lists that come up for consideration in recent times. This seems to be a pattern which is not limited to the Federal High Court. There seems to be a pattern. It appears to be a new trend that private legal practitioners are now deemed less worthy of appointment to the bench. While we do not suggest that judiciary staff, prosecutors, and civil servants are not eligible for appointment, we deprecate a system that seems to give them prominence over private legal practitioners. The majority of appointees should be the practitioners who practice daily before the courts to which appointment is being considered, and therefore would appear to have the more requisite experience. This concern has necessitated our call necessitated a repeat of the NBA's call for the amendment of Rule 3.4 of the guidelines and procedural rules for the appointment of judicial officers of all superior courts of record in Nigeria, which empowers the Chief Judge, as the Chairman of the Judicial Service Commission or Committee concerned, to make a provisional shortlist on the merits consisting of not less than twice the number of judicial officers intended to be appointed at a particular time. This rule gives a lot of power to the Chief Judge and the Chairman of the JSC, and would appear to be used in a manner that may not always be merely driven. We are of the view that processes that leads to the shortlist of candidates needs to be further reformed and made more transparent. The Chief Judge should not be solely responsible for preparing the shortlist. The general perception is that the appointment of judicial officer is influenced by politics. The mode of appointment should be such that more parties, especially independent parties, should be involved. The mode of appointment of judicial officers is therefore general principle. In the communique issued at the end of the General Conference in Port Harcourt in 2011, the NBA observed there are a lot of legal practitioners in Nigeria who are not only honorable, patriotic, transparent, hardworking, and incorruptible, but also fit and proper for appointment to the bench and elevation to the but are bypassed on account of mundane considerations, especially the fact that they should allow those who have labored and suffered on the bench to benefit from such appointments, quote and unquote. After all, it is said that these private legal practitioners have been enjoying themselves. We opine that if it is indeed, it is based on connection as many believe it is, it can only lead to the involvement or interference by non-judicial or legal actors in the process. The involvement of politicians in the appointment will no doubt ultimately lead to interference by these individuals in the judicial process. Such interference will wrongly justified as a payment of favor. Persons selected for judicial office shall be individuals of integrity and ability with appropriate training or qualifications in law. Any method of judicial selection should safeguard against judicial appointments for improper motives. As we have pointed out repeatedly, the poor quality of appointments in the judiciary will be the bane of that judiciary. We therefore propose as follows. Those who apply for appointments as judicial officers, especially to the High Courts, Federal High Court, NIC, should be subjected to written tests conducted by an independent board. The results of such an examination should be published within 6 hours of the completion of same. Presently, even though there's a written test, the results are never published. And it is never easy to say whether reliance was placed on the outcome of this result for the shortlist. Such an examination should not only test their knowledge of the law, but equally test their verbal and quantitative aptitude. Thus, the test should be structured in a manner that ensures the prospective judicial officers show their legal writing skills, comprehension, and legal reasoning skills. Judicial appointment process should be reformed to focus on skill, professional and technical ability in addition to integrity and personality. Appointments into the bench at whatever level must henceforth be predicated upon merit and concurrent recommendation from the bar. My lords, may we respectfully note that the bail process continues to be a tool of abuse of judicial power, oppression, unjust demands, overcrowding of the detention center and delay in many courts in Nigeria. This abuse is best highlighted with order made by the Chief Magistrate Court last week, Obi Nanjemanzi, for the remand of the Owerri Correctional Center of our colleague Chinedu after arraignment on charges alleging cyber stalking, criminal defamation, and incitement. Some judges and magistrates are increasingly becoming enablers of political oppression and suppression of dissenting views by remanding persons charged with alleged criminal defamation or cyber stalking under Section 24 of the Cybercrime Prohibition and Prevention Act 2015. Judges and magistrates increasingly deny bail when such charges of internet or online related offenses are preferred against defendants despite the matters being ordinarily bailable. It is then worrisome that even though the law provides that a court may require a suspect or defendant to execute a bond with or without sureties for his appearance before a court, our courts rarely utilize such procedure. Rather, the bail process has been rendered very technical, time-wasting, and cumbersome. Sometimes court impose bail conditions that amount to denial of bail. At other times, they will impose a condition requiring the prosecutorial agency or some other third party to verify sureties before a defendant could be released on bail. This has led to allegations of extortion, abuse, and prolonged detention even after bail has been granted because of the deliberate delay in verifying such sureties. This has also given the impression that justice is not served in such circumstances, but that the judges may have rather chosen to enable the unjust incarceration of citizens to say that which makes for saying that which makes somebody unhappy, uncomfortable. It is well known that the essence of bail is to ensure that the defendant attends court to answer charges that may have been brought against him. It is therefore worrisome why a court will refuse bail to a person charged with an offense that does not carry more than 3 years imprisonment upon conviction. Judges and magistrates who deny bail to defendants in such circumstances must know that the judiciary should not be seen under any circumstance to side with those who wish to silence criticism, dissent, and refuse to be held accountable. I need not remind us that when the government of Jimobodo charged Chief Atomwankwe, publisher with sedition, for writing a book in 1982 titled How Jimobodo Rules Anambra State, a book that seriously attacked Chief Jimobodo, then governor of Old Anambra State, accusing him of corruption and tyranny, the Court of Appeal in quashing his conviction by the High Court, held that sedition law, that is sections 50 and 51 of the Criminal Code, is inconsistent with section 36 of 1979 Constitution, now section 38 of the 1999 Constitution, and therefore void, and the conviction of Arthur Nwankwo was overturned. In the judgment of my Lord Honorable Justice Olatawara JC, as it then was, in quashing that judgment, the citation is applied here. It is my view that the law of sedition, which has derogated from freedom of speech, guaranteed under this constitution, is inconsistent with 19th Constitution, more so when it cannot lead to a public disorder, as under section 41 of 1979 Constitution. We therefore use this opportunity to call on the chief judges of the Federal High Court and the High Courts of the states and of the Federal Capital Territory, Abuja, to exercise powers given to them by section 187 of the ACJA and by the requisite provisions of the ACJL by making regulations for the registration and licensing of corporate bodies or persons to act as bondspersons within the jurisdiction of the court in which they are registered. We must make a commitment to ensure that the voting process is made in such a way that ensure that the defendant appears in court to face trial and same is not abused. We will not fail to use this opportunity to call attention and deprecate the stateful circumstance surrounding the hearing of the appeal filed by a colleague, Bright Ngene, against his conviction by a magistrate court in Enugu State. The prolonged delay in determining the appeal gives an impression of a deliberate effort to ensure that his appeal is never heard. It is disturbing that the matter which initially reached judgment stage was truncated on the very day of judgment because the judge refused to deliver judgment and proceeded to recuse himself. Owing to the public outcry and the long delay in assigning the matter to another judge, the matter was assigned to another judge who unfortunately on the 23rd of September 2025 recused himself yet again. It is beginning to look as if there is a concerted effort to ensure that the appeal is never heard, so that Bright Ngene will serve the full term imposed on him by the court. If this is indeed true, then this is not the face of justice we want to present to the world. We wonder if the judiciary in Enugu State has become weak, unwilling to live up to the judicial oath to do justice to all men without affection of ill will. For how long shall we allow the cumulative effect of the violation of Mr. Ngene's right to a fair hearing and timely hearing of his appeal? This is, to say the least, is a painful reflection of systemic delay that is decreasing public confidence in our judiciary delivery institutions. It is a convenient point to remind us yet again of Lord Atkins' statement in his certain judgment in Liversidge and Anderson. And I quote, "In England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which recent authorities we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified in law." The continued detention without any judge accepting to hear Bright Ngene's appeal strikes at the heart of our collective sense of justice as a profession. Bright Ngene deserves such justice, and the willful refusal of the judges of the Enugu State High Court to hear his case, I repeat, strikes at the heart of justice and portrays it in a bad light. According to an African proverb, if the crocodile eats its own eggs, what then will it do to the flesh of the frog? My lords, I respectfully crave the court's indulgence to address the matters that have weighed heavily on the public conscience of our nation. Some time ago, there was outrage over the arraignment of 75 protesters, including 32 minors, who were charged with serious crimes like treason and incitement to mutiny. Arrested during August embarked government protests, the young defendants, evidently weak, unkempt, and malnourished, were presented in court after nearly 3 months of detention. The case brought to the fore the treatment and application of laws to minors in conflict with the law. It also highlighted the absence of detention facilities or boster homes for detention of minors, as well as highlighted failure to seek alternatives to remand for children or minors in conflict with the law. The case calls to mind the role of the judiciary in ensuring that where the prosecution insists on doing the wrong thing, the court would come to the aid of such ones. Our courts are urged to develop best practices to ensure that children are neither charged along with adults nor sent to adult detention facilities. The court should also activate the provisions of the law about how to determine the age of children where there is doubt about sin. The issue of digitizing our courts remains pressing. The Supreme Court Rules 2024 provided a foundation for electronic filing, but the system is yet to achieve full operationalization across our superior courts. Our courts still struggle with manual processing that encourage delays and inefficiency. In 2025, this should no longer be acceptable. Many jurisdictions have shown that technology can drastically improve efficiency, transparency, and public trust. Nigeria must not lag behind. The NBA therefore renews its call for adoption of electronic filing and service of processes, digital recording of court proceedings in all superior courts of record, efficient case management system with strict scheduling and time slots, integration of legal mail as exclusive medium for court-lawyer communication. No judiciary can command respect if questions persist about the discipline and integrity of its officers. The NJC must be unwavering in upholding ethical standards while at the same time protecting judicial independence from political interference. As a dearly late beloved past Chief Justice of Nigeria, Mohammed Lawal GCON, said, for a judiciary to function effectively, it must have the trust and confidence of the people. This trust must be strengthened only when judges are seen to be above reproach and when the processes are swift, fair, and transparent. We must therefore renew our focus on access to justice for indigent citizens, spiritual of cases, and regular inspection of detention facilities to curb unlawful incarceration. The judiciary is not an ivory tower immune from the gaze of the people. It is an institution that must constantly earn public trust through fairness, timeliness, and transparency. Many magistrates and high courts operate with derisory infrastructure, from poor electricity supply to a lack of recording equipment, making effective case management difficult. The viral video of the leaking roof of a magistrate court in Anambra State highlights the neglect into which the inferior courts have fallen into. We therefore use this opportunity to call on all the persons responsible to make intentional efforts to improve the infrastructure of magistrates and judges of lower courts. To our colleagues, newly conferred with the rank of senior advocates of Nigeria, and members of the INABA, you have my hearty congratulations. Your elevation is the product of excellence and hard work and integrity. The rank is not an ornament, it is a call to higher duty. You are now among the torchbearers of the profession, mentors, leaders, and custodians of justice. Younger lawyers look up to you, not only for technical brilliance, but for ethical guidance. As you don the silk, may you remember always that privilege comes with responsibilities. We urge you to adhere to high standards required of the rules of professional conduct. We will not hesitate to investigate and initiate disciplinary action against any legal practitioner if a prima facie case is made against him or her. We are currently investigating allegations against our colleagues, whom it was found by Judge Ewan Partin of the First Tier Tribunal Property Chamber Land Registration in the United Kingdom to have contrived evidence in order to secure the registration of a property in their favor. We have in particular written a letter requesting explanation, first of all from Chief Mike Ozeko-Mesen, and as soon as we get the addresses of the other persons who understand our Nigerian laws, also send similar letters to them, so that they will all have an opportunity to explain. The MB also traces call for a review of the guidelines for conferment of SN rank to broaden inclusivity, particularly for academics and law teachers. We also call for the removal of the guideline that requires that a person facing disciplinary action or a pending criminal case should not apply for the rank until the termination of the case. It is our belief that this negates the constitutional presumption of innocence and indirectly imposes punishment on the person who may otherwise be innocent. Such a person should be able to apply, as the system can always kick in to weed him or her out if there's a finding against them either in a disciplinary process or in a criminal proceeding. Not to be forgotten is the fact that the provision can be abused to ensure that a person does not apply for or even get a rank. We believe that since there is a procedure for withdrawal of the rank among early lessons, the above requirement has become odious and unconstitutional. As we commence the new legal year, let us recall the words of Justice Taslim Elias, that justice is the greatest concern of man on earth. Our collective duty, the bar and the bench alike, is to ensure that justice is not a distant ideal, but a daily reality for all Nigerians. The NBA pledges its continued partnership with the judiciary to pursue reforms, advance digital transformation, enhance access to justice, and strengthen discipline within the profession. May this new year mark a turning point in our collective resolve to restore public confidence in the judiciary and to build a justice system worthy of our democracy. Thank you for